In this video, we're going to take a brief look at intellectual property. So intellectual property, or IP, is the intangible property that is the result of creativity such as patents, copyrights, etc. Okay, so the key phrase there is the intangible property, so it's what can't be touched, and that's why it's what we call intellectual property. And according to my colleague Dr. Stephen Castle, intangible property that is usually the result of creativity that bestows ownership, right to exclusivity and ability to exploit. So it's the intellectual property is about it's the person who created it having the rights to use it as they see fit, is what he's saying there. Intellectual property focuses on copyright, often seen by the C, trademarks, often by the little TM, or patents. So let's have a look at those in more detail. So we'll start with copyright. As always, let's start with a good old definition. So copyright is the right to disseminate literary, artistic, dramatic or musical work. So it doesn't maybe mean you own it, but you have the right to use it. It can be a sound recording, film, broadcast, etc. So the main one that we know about with copyright is music and films and how they can't be showed unless you have permission, etc. There we go. A literary work can be a computer program or a sales catalogue. So even the IKEA catalogue, which is rumoured to be the #1 published book in the world, can't be reproduced unless with permission. And even there, as well, as they say, a computer program is actually protected under copyright, even though it's just lines of code and zeros and ones, it's still protected. An artistic work as well there can be a photograph. So if you take a picture of something, so there was a great case a little while ago about a monkey that took a selfie, and who actually owned the copyright? Was it the monkey, because he was the photographer? I think it was a he, I can't remember. Or was it the photographer who gave the monkey the camera? So that was an interesting one, because I suppose that broke the copyright laws. We'll find out later. And there we go, dramatic work can be a commercial. So there is a thing as well at the moment of parodying adverts. So a lot of companies will parody other adverts, especially Christmas adverts, etc. But a commercial is also a dramatic work. So we're not just talking plays, we might be talking TV adverts as well. There we go, we can see all the history of the copyright going back to 1709. I think from my art history, actually, the copyright was brought out by I think it was, I can't remember who it was, but somebody did engravings. Hogarth, I think, did engravings, and then people kept taking copies of his engravings. So he created something to create the Copyright Act. I think I might be wrong there. The key thing is it started in 1709. So I don't know why. The why might be wrong, but the when is definitely correct. You can see there tweaks and changes throughout the years. So when can you have a copyright? So when you have a moral justification, an economic justification, a social justification. Okay, so the moral justification is it's your work. Economic justification is that there's money attached to it, obviously, and the social justification. Okay, dissemination of work in return for payment or enriching culture and providing the foundation for further creation. So there's there's a social reason to do it. So the copyrights, what they cover, I think we've already covered this really, but according to the Copyrights, Designs and Patents Act 1988, this is what they cover. Original literary, dramatic, musical or artistic works, we talked earlier what they are. Sound recordings, films, broadcast or cable programs such as this, or TV programs. Game of Thrones, I think, is the most illegally downloaded program of all time. Typography arrangements of published editions. Okay, so that links to, well, arrangements of published edition links to the obvious things such as, I was going to say the works of Shakespeare, but that would be wrong. So we'll find out later why. It links to, certain plays, can't be done, etc. Typographical as well, arrangements. Can also look at font type. So the Disney font type is copyrighted. The Coca-Cola is, trademarked is that one actually. So even certain fonts have copyright issues. Here we go, so here's an explanation of the work then. Literary work is any work that is written, spoken or sung other than dramatic or musical work. So any a cappella, House Mountains Caravan of Love then, so it is sung, even though it's not technically musical work. And that's all covered under the literature works. The dramatic works then, as you maybe see, the acting, the dancing, even the mime, can be copyrighted. So I don't know if somebody's copyrighted the invisible pulling of the rope or the invisible climbing of the ladder or stuck in a glass box. I don't know, maybe you can look into it and copyright it. And there we go. The work must have sufficient unity to be capable of performance. So an interesting one there, I think it's in the musical one. There is a piece of music called 3 minutes 42, which is actually just silence for 3 minutes 42. 3 minutes and 42 seconds. And therefore a lot of pieces of music that have a gap in them, they sometimes have to cite 3 minutes 42 as the original work, because that was copyrighted as silent music. I think it's what's it called? It's a certain performance art where every time it is played it is a different type, and so the 3 minute 42 is every time it's played, obviously the audience chatter and the background noise is different, and that's where it gets its sufficient unity and is why it's a performance piece. Musical work is a piece of music, so the 3 minutes 42 is clearly a dramatic work, not a musical work. And then artistic work, as we'd looked at before, photography, sculpture, collage, irrespective of how good or bad it is, so whether it's a Pollock, which some say is not a great artwork, I'm not going to get into that argument, or a Rembrandt, it doesn't matter if somebody's drawn it. If it's the 5-year-old's picture on the put on the fridge, it can still all be copyrighted. A work of architectural building, or a model for a building, so certain buildings can be copyrighted, so like Sydney Opera House or the Dome, etc., or a work of artistic craftsmanship, so just a certain chair. So there was a big thing for cabinets and chairs, Chippendale cabinets and chairs. Once again, they could have artistic copyright. So we talk about two main things. We talk about the author. So the named person usually that creates it is the author. And sound and recordings is the persons that the name's on it. And then we have the owner. Usually the owner is copyright is the author, and they can issue it as a license. So I can't remember who the author was, but I believe it's somebody like Disney owned the right to the Happy Birthday song, and they can let you use it if you pay them a fee. There you go. You can be joint ownership, so different people can own a copyright. Different companies or people can own a copyright. And as we said there, they can let you use it as long as you pay a certain amount. So I think in England we have something called the PGT adverts, and that's advertised by somebody called Monkey. And Monkey is actually copyrighted to Red Nose. So you can use Monkey if you pay the Red Nose charity a fee. Future or prospective copyrights may be assigned as when finance for films is being obtained. So you can actually obtain copyrights for future things. So I think it was Disney again. They have Kung Fu Panda, and then they copyrighted Kung Fu and just about every word after that. So, you know, Kung Fu Tiger, Kung Fu Snake, Kung Fu. And that's why there was the Karate Kid film with Jaden Smith in it and Jackie Chan. And they initially wanted to call it Kung Fu Kid. But because Disney had already copyrighted all future potential works that they may use with the prefix Kung Fu, they couldn't, and that's why it was called Karate Kid. Here's an interesting, where an employee creates a work in the course of employment, the employer is the owner. So most university lecturers, when they create lectures, etc., their university owns the copyright, not the actual lecturer. It's an awkward one. So if they're doing something for the university, then the university could create the copyright. But there are moral rights. Oh, there we go. The rights to the creator of the literature, dramatic music, artist, work, the director of the film. So once again, they're identified as the author of the work. So they have what's called a paternal right because they created it. They have the right to the integrity, which means it cannot be derogatory treatment of their work. So they can't use it without a good reason. Trying to think, the best one there I think is Edvard Munch's Scream. The amount of copies that there have been of the Scream. I think there's a Simpsons copy of the Scream, etc. Which would maybe go against this right of integrity, but once again we'll have a look at time lapses and we think that'll be fine. Once again, to prevent false attribution of work, so it's got to be to the right person. Ooh. Once again, sometimes somebody might pay for a photographer. So let's think wedding photos. So we just said earlier that the photographer owns the copyright. But if you pay the photographer to take pictures of your wedding, surely you own the copyright because it's your wedding. And the thing here is saying, yes, if you've paid them, so you've commissioned them to do it, therefore you do own the copyright. So an interesting one would be the Mona Lisa, Leonardo da Vinci's Mona Lisa. So he was paid to do the Mona Lisa. So who technically owns the copyright for that? Is that Da Vinci or the person that paid for it? Moral rights, as we say there, may be waived, so people can give away their rights to copyright ideas. There we go. Copyright will only be protected in the UK if the author is a qualifying person, so that they're resident of the UK or citizenship of the UK, etc. Or the work was first published in the country or part of the Berne Convention or Universal Copyright Convention countries, so any one of those countries, and therefore it still has a UK copyright. Or the broadcast or cable program was made or sent from the UK. So once again, programs that are made or sent from the UK have automatic UK copyright. And as we said earlier, certain things on copyright only actually last for a certain amount of time. So on literature, dramatic, musical or artistic works last the life of the author plus 70 years. So as I said, Edvard Munch's Scream is probably out of copyright because, well, actually I don't know when he died, so I don't know if it's been 70 years since he died. So a few years ago we lost David Bowie, amongst loads of other musicians, we lost David Bowie. So his music is still copyrighted to him or to his estate for the next 68 years because it was a couple of years ago we lost him. Computer works only last for 50 years. And that's the calendar year in which the work was made. So once whatever we're on now, Windows 10 or wherever we are, I can't remember where we're at. So when that was made, that's when the copyright clock starts kicking in. It's only 50 years after that. Once again, with computers, I think it's very easy because there's Moore's law, isn't it, where computers are going to be twice as fast or half the size or half the cost within 18 months. So 50 years isn't an eternity in computing. When we talk about secondary works, things have a duration. So sound recording, broadcasts have 50 years, typographical arrangements 25 years, and films 70 years, following the death of the last to die of the principal director or author of the scheme. So whoever created is deemed as the author and owner 70 years after that. So trademarks. Introduced in the UK by the Trademarks Act of 1875, so remember copyrights was 1709, so this is a few 166 years later. The trademark is an indicator of the origin of goods or services, so the little TM there is the origin of it. Protects the manufacturer or provider against competitors. The mark will identify the manufacturer or provider and as a guarantee of quality to the consumer. So this is why people are very particular over their trademarks. Certain things are trademarked, such as the word should have, as in should have gone to Specsavers. Technically, I think I owe Specsavers some money now because I've used their trademark. The colour purple and the colour red are copyright to Cadbury's and Coca-Cola respectively. The colour brown is to UPS, etc. As I said before, Coca-Cola's ribbon logo is copyrighted to typeface, or is copyright to Coca-Cola, etc. So all these little things, they stop people copying it, and they let you know that that's the right kind of brand. How do you register one then? You have to go to the branch patent office, get an application form, let them know exactly what it is you want to trademark, where you're going to put this trademark, because different things can have, different companies can have the same kind of name or trademark. I think Apple was the big one. So Apple was a record label years ago, as well as the computer firm that we know. So certain things can actually have similar trademarks. So that's why you have to give a list of goods and services which you intend to put the trademark on. And then once again, when you file for it, that's the date that it's given. So when we talked about certain things go out of date, then it's the date of the priority date when it was filed for. There you go. Initial registration is for 10 years. It may be renewed every 10 years, an indefinite number of times. As long as you pay, you can renew it. So Coca-Cola can keep that ribbon logo for 10 years, and then if they pay, they get it for another 10 years. If they pay, they get another 10 years. Usually they get first dibs on it, so they pay and they get another 10 years. If they don't pay and they don't want it, then you can pay and you can have it. Any disputes are dealt with the registry or in the High Court. Any disputes with trademarks are dealt with the registry or the High Court. So I think Apple tried to take Samsung to court over the shape of the smartphones. For some reason, they thought a rounded corner rectangle, they owned that shape, but we'll see. There we go, and it grants exclusive use in the course of trade. So if you have that trademark, only you can use that logo, that design, that quirk, that feature, that whatever it is. So as we said, Apple tried to take Samsung to court over the rounded corner square because they reckon they designed that. There we go. Trademarks can be signed or licensed. As we said, yeah, Apple have the all the trademarks in place for their thing, but they issue it out to people to make it on their behalf. Okay, so no longer need a link between the proprietor of the trademark and the goods for which it was registered. So there's not always the obvious link between what it was and why it was registered. And once again, there you go. Certain people have trademarked their names, such as Elvis Presley. David Beckham, I think, that's a registered trademark, is David Beckham. Interestingly, Kylie Jenner tried to trademark her name, but unfortunately it didn't work because there's already a famous Kylie and Kylie Minogue, so they couldn't trademark it. And we'll find out why a little bit later on. In character merchandising, it is necessary to show a link between the name or image of the character and the product or service in the minds of the public. So once again, Beckham's got his trademark footballing career, Elvis have his trademark dancing and sound, etc. So you can see a real link between the person and what they're trying to portray as a trademark. Patents. So modern patent law encourages free disclosure of information in return for a limited period of monopoly. So when you get a patent, sometimes they ask you to let other people know about it, so that obviously you can keep the monopoly of it. An interesting one with patents actually is there is still a car company owns the patent for seatbelts, but they let all the other car companies use it because they know the benefit of a seatbelt. They think this is better for the human race to have seatbelts, so they let every other car company use it for free, even though they designed the seatbelt, but they let everyone else use it free. They did patent it, but they let everyone use it, and that car company was Volvo. Once again, this is why people like the patent, because they then get to monopolize it for a few years. So if you can come up with a patent, you are allowed to monopolize that idea for a few years before the patent runs out. There you go. After 20 years, that's when it runs out. And this one, I don't think patents can be renewed. So after 20 years, people then start to use it. But once again, in most business cases, 20 years is an eternity and you've already made your money out of it. So you let the Patents Office know and you get 20 years to use it. I think that's just a repeat slide. I'm sorry about that. There you go. So it gives justice, as it says there, to the inventor for the ingenuity and labour. So this is why people do it. It gives you that sole use of it. So it really helps you move forward with your company or whatever it is you're trying to do. Encourages inventions through competition. Companies race to be for the first. Every company tries to be the first. So I think it was I was watching something the other day and it was Dr. Pepper that was the first. So Dr. Pepper is actually one of the oldest fizzy drinks companies. It is older than Coca-Cola and Pepsi-Cola, but it was the first one to learn how to bottle fizzy drinks, because before that you had to go to like cafes where they would give you the soda, the fizzy drinks, because that's how they could put the carbonation in. They couldn't work out how to bottle it, but Dr. Pepper was the first one to be able to bottle it for home usage. In the UK, so we have the Patents Act 1977, and then as you've seen, they've all been amalgamated copyright designs and patents in 1988. Internationally, we've got all these different ones here. I'm not even going to go into it because I don't know what's happening with Europe right now, and therefore I'm not going to go into them European things. So how do you get your patent? So you prepare and file an application. You have to make searches for what they call novelty, so it has to be unique enough that it's different. You can't just take someone else's idea, change a few screw heads on it and call it your own. There has to be enough different there to make it your idea. It then goes through a panel to make sure it's unique and different. Any objections, you get the right to reply, so that's quite nice. Rather than them just refuse it, they go, okay, we don't like this. So you might change it. Then it's granted, and you have to pay and renew every year. As we said, maximum up to 20 years. Things that are then excluded from patents, scientific theories. So if you have a scientific breakthrough, you have to publish. So whether you want to keep that, for yourself to make billions out of it, apparently no, they're not due to the patent. So you don't have to publish it, sorry, but people can copy your idea. So if you cure cancer, I'm afraid it's going to be taken. Presentation of information, once again, excluded from patent. There you go. Schemes of doing business, so a way of doing business cannot be patented, so they say. Method of treatment of human or animal bodies, once again, links back to what I was saying about the scientific breakthroughs, etc. As we said, one of the things that has to happen for you to get a patent is this novelty, so it must be different to anything else. Once again, there must be a real step forward. So you can't just do something that's already out there, but because people haven't patented it, so I'll jump on it. And you go, no. If it's already out there and it's not a move forwards, then we're not going to just issue you a patent. And there must be some industrial application. Okay, so you can't just patent something for the laugh of it. Your name, if your name's not going to be worth anything, then they're not going to let you go through the whole process of patenting it. Here we go. You can copy certain things as long as it's done privately for purposes which are not commercial. So I don't know, maybe you like to just take the mickey and reshoot film posters. So as we said earlier, photograph is copyrighted, and the film poster would be a work of art, so therefore it's deemed you can't copy that. But if you're just doing it, say, for your mate, so you're putting your head on someone else's body as a joke to link to a famous film, then there you go. If it's done for experimental purposes, so if you're trying something new, trying something different, apparently you can't be infringed. Oof, what a lot of word. So it helps humanity. It consists of the use exclusive for the needs of the relevant ship of a product or process in the body of the ship where the ship has temporary or accidentally entered the internal. So if you're out of UK waters. Dear, same again, you're out of the UK area. Same again. So you can have your patent revoked if it is not valid patent. So once again, they do get it wrong, and just because you think you've got a patent, if it's too similar to one that's already been filed, unfortunately you lose out. You haven't let them know fully what it is. The applicant is not entitled to the patent. An amendment has not been made to the patent that is not permitted following a grant. So they haven't said you can get one. Obvious reasons there, I think.